Hi, welcome back to Busch History. This presentation is going to deal with pivotal Supreme Court cases. Cases that have changed American history and set the precedent for future generations. Now, the whole idea of a precedent-setting case, and the word precedent is right here, means that whatever the decision that's rendered by the Supreme Court, the future courts will look back and see what did the previous court do? What decision preceded our decision? Precede being part of the root precedent, and the Supreme Court will often take into account the opinions and the actions of the previous court in making up its decision on whatever the current case might be. There are many cases in American history that set precedent. There are many cases in American history that create milestones in American history. The ones I'm going to take a look at with you today are considered the upper tier, if you like. There are more, and there will be another presentation. This is called Supreme Court Cases 1. There will be a Cases 2, but just to get us going to the early part of the course, I wanted to get this up here because when we get to the Jefferson administration, we get to the first big one, and that's going to be Marbury. Marbury in 1803 sets up the precedent of judicial review, that the Supreme Court can review laws passed by the United States Congress and can turn around and declare that those laws are null and void, or the term unconstitutional is used. So that would be Marbury. McCulloch in 1819 briefly deals with a bank and who has more control in a state, the federal government or the state government, and the Supreme Court under John Marshall will rule that the state government is subordinate to the federal government. Gibbons in 1824 is almost a revisit of McCulloch in 1819, where the court looks at the precedent, and the precedent is the federal government is supreme. Dred in 1857, the famous case that almost everybody knows about, can a slave sue for his freedom? The Supreme Court ruled that wasn't the question. The question is, does a slave have any rights in a court to bring suit whatsoever? Then we're going to go over here to Plessey in 1896, and that's going to deal with the whole idea of, can states set separate facilities for blacks and whites, the idea of separate but equal, and that will come into play in 1896 with Plessey. Schenck in 1819 has to do with how our rights viewed during time of national emergency. In 1917, World War I was going on, and Schenck is dealing with that. Do we have absolute right to freedom of speech during a national emergency? Then we go to Brown in 1954, probably the granddaddy of them all. Everybody knows something about Brown. And that's going to have the whole effect of, is separate but equal actually legal? Is it constitutional? And then Miranda in 1966 is the case that, if you watch TV shows a lot, especially police dramas, we all know about the Miranda rights. What rights does the accused have when he or she is arrested? Do they have right to counsel? Do they have rights to remain silent and stuff like that? So that's going to be the purpose of these cases as I take a look at them with you today. So if you want to hold up for a second, I'm going to cue up some notes on these cases, and we're going to take a look at them together. Before I go, just want to remind you that this note set with the rest of the entirety of the materials I use as part of Busch History is available on buschhistory.net/YouTube, and you can take a look up there and you guys see this exact note set, and it'll be in a folder and it'll be clearly labeled Supreme Court cases. So let me cue this up. Probably the most well-known of the early Supreme Court decisions has to do with Marbury and Madison. A little background here, and then I'll take a look at the information with you. The election of 1800 comes along, and Thomas Jefferson defeats John Adams in a very close election, has to be decided by the House of Representatives. Well, Thomas Jefferson wins, but Thomas Jefferson is a Democratic Republican, and John Adams was a Federalist. So while they may have been friends, they were also political adversaries. They looked at the government differently. The Federalist John Adams believed in a strong central government with a lot of power being wielded from the capital over the states. Subordinate state governments for sure, and whatever the federal government was supreme. A lot of laws, a lot of rules, a lot of regulations coming from the federal government. Thomas Jefferson, remember, he's the writer of the Declaration of Independence, and Thomas Jefferson does not feel the same way. He thinks less is more. We need less government. The states can decide more on their own what they need to do and how they need to handle things. So he has a different interpretation. Remember, the Declaration of Independence and the Constitution are opposite documents. They are opposing. The Declaration of Independence affirms the rights of the people with life, liberty, and the pursuit of happiness, and even mentions that when a government is unable to fulfill those goals, that the people have a right and a duty to change that government, hence overthrow that government in a revolution. Well, obviously the Constitution feels differently about that, and that is the document that guides John Adams. Not that it doesn't guide Thomas Jefferson, it certainly does, but Thomas Jefferson thinks the federal government has way too much power. So John Adams, in his closing days, in the early spring of 1801, just before Thomas Jefferson becomes president, assumes the presidency, signs a document that basically appoints, I think it's 45 judges to the federal court system. The number is not really relevant because there's a lot. And these are all Federalist judges. These are people that John Adams has political similarities with, which means they're different from Thomas Jefferson. He gives those appointments to his Secretary of State, a fellow by the name of John Marshall, who will become very famous through this case and through future decisions. So John Marshall is supposed to deliver these appointments to the Senate, because the Judiciary Committee of the Senate is the one that approves these kinds of things, as part of the Judiciary Act of 1789. Well, John Marshall, for reasons that are really not well known even today, does not deliver the appointments, with one exception. He delivers his own. So John Marshall delivers his appointment to be Chief Justice of the Supreme Court and nobody else's. So acting as John Adams, Secretary of State, he delivers the appointment that creates the job for him to be Chief Justice of the Supreme Court and delivers no other appointments. Okay, fast forward a little bit. John Marshall becomes Chief Justice of the Supreme Court, John Adams is out of town, and Thomas Jefferson is President of the United States. And a fellow by the name of William Marbury wants to know why he doesn't have his job. He was nominated to be a Justice of the Peace. Not a very high-ranking judge. Marriages, your horse is parked in the wrong place, you oversee some local things. But he wanted the status of it. So he turns around and he brings a lawsuit. And he sues James Madison. And people often wonder, why does William Marbury sue James Madison? Because he's suing the position. The position that delivered the appointments was the position of Secretary of State. John Marshall, as John Adams Secretary of State, had been instructed to deliver these appointments. So James Madison, as Thomas Jefferson Secretary of State, would be the logical person to deliver the appointments should they want to follow through on John Adams' initial instruction. Of course, Thomas Jefferson doesn't. He doesn't want these people to become judges because they will handicap him. You would have a Federalist-dominated court with a Democratic and Republican president, and you'd have a lot of things being overruled that the president puts into play. So now, William Marbury sues James Madison to have these appointments put in place. Well, now we have a problem here, because who is going to take a look at this and decide? As it meanders its way through the federal court system and ultimately makes its way to the Supreme Court, John Marshall is the Chief Justice of the Supreme Court. So John Marshall is going to sit in judgment of a situation that he created, but not delivering the appointments in the first place. Which is certainly ironic, and there wasn't any place else to go. It was John Marshall or nothing. Now John Marshall, he's got to think about this, because if he decides that William Marbury should be appointed, then he's deciding the rest of these Federalist judges should be appointed, and he's really dooming the Jefferson presidency to all kinds of friction between the executive and the judicial branch. If he rules in favor of Madison, then he's ruling against John Adams, the person who gave him his job in the first place, and so much for political loyalty. So he doesn't really know what to do with it. He's going back and forth, and we kind of know he didn't want William Marbury to be a judge because he would have delivered these appointments in the first place, and we know he didn't. So what he's going to do is he's going to come up with another way. He's going to rule that the Judiciary Act of 1789, the law that all these appointments are based on, was unconstitutional. That this Judiciary Act gave the president too much power to appoint judges, and that the federal level of judges, not the state level of judges, but the federal level of judges, did not have original jurisdiction. So in essence, he's going to rule against Marbury, but not for Madison. He's just going to rule that the Judiciary Act of 1789 is largely unconstitutional, and that the federal courts do not have original jurisdiction and that Marbury started in the wrong place. So let's actually take a look at the notes and see if we can figure this out together, or at least examine it together. So, the question comes down to, the year is 1803, the case actually begins in 1801. Should the Supreme Court grant William Marbury's appointment as a Justice of the Peace? Hard call, because if they do, if John Marshall does, he's ruling against Thomas Jefferson. If he doesn't, he's ruling against John Adams. So, in the closing days of Adams' administration, Adams appointed many Federalist judges in an attempt to blunt the influence of the Jeffersonians, or the influence of Thomas Jefferson. John Marshall, the Secretary of State, was given the task of delivering the appointments. He delivered only his own. Now, was John Marshall a genius, and he said that this is a bad idea? I really like to think so, but we just don't know. Anyway, so on the right side of the outcome in the charts that were precedent, to rule for either Marbury or Madison would mean to rule for one president over another. Don't confuse the word precedent and president, by the way. So, avoiding ruling for or against a president, Adams or Jefferson, John Marshall ruled. First, the Judiciary Act of 1789 did not allow federal courts to have original jurisdiction. If you have a problem, you start in your local court, and then you have to go through the State Court of Appeals to get into the federal court system. Marbury started in the wrong court. So, one strike against Marbury. Number two, elements of the Judiciary Act of 1789 are unconstitutional, meaning that the President did not have the power to appoint an unlimited amount of judges, and even the thought of original jurisdiction beginning in the federal courts does not make any sense. And finally, three, the use of judicial review by the Supreme Court became a precedent for future cases. Because now John Marshall, he's not ruling for or against a person, he's ruling about a law, the Judiciary Act of 1789. And he's going to rule that act to be largely unconstitutional. So that's the beginning of judicial review. So Marbury does not get his appointment. He does not get it. Madison doesn't win and Marbury loses, that's for sure. But you have to be careful how you word it, because if you word it that Madison wins, then you don't understand the decision. The decision is that the law that all this was based on was fundamentally flawed, thereby unconstitutional. So the precedent we get here is the idea of judicial review, that the Supreme Court can determine whether a law is valid and constitutional, and if it's not, it can nullify that law. It does not write another law. That's up to the legislative branch, but it can nullify an existing law upon examination. But remember, in order for a case to get to the Supreme Court, someone has to bring suit, and then the Supreme Court decides whether to hear the case or not, and that case, that decision depends on the merits of the case and its national implications, and how the Supreme Court decides the lower courts have handled the case. Next up will be McCulloch versus Maryland. So now I'm going to deal with the case of McCulloch versus Maryland in 1819. A little background is necessary here. In the latter part of 1818 and 1819, there's a bank panic in the United States. As a result of speculation and a lot of borrowing by individuals, the banks were low on funds. As a result of drop-off of international trade that occurs in the waning days after the War of 1812, tariff money is down, so the primary source of funding into these banks, the tariffs, is down as well. So the banks are short on cash, and they have to pay back creditors. So because they don't have money to pay back the creditors, they start calling in money from debtors any way they can so they can pay back the creditors, and they start getting a little inventive in ways of raising that money. So remember, this is geared to the panic of 1819, and that panic is going to have far-reaching implications. Because in that panic, Andrew Jackson's family is going to lose a good deal of money, and because of that, he's not going to be very happy. But we'll deal with that when we get to the Jackson presidency. So what happens is, the two players are McCulloch v. Maryland. Now you have to understand, when you look at how a Supreme Court citation occurs, the first person is bringing suit against the second. So the first person is the plaintiff, the second person is the defendant. McCulloch is the plaintiff, McCulloch is bringing suit against Maryland. McCulloch is the president of the Bank of the United States located in Maryland, and Maryland is the state of Maryland. And what's happened is, the Maryland banking system is losing money as well as the federal banking system. So in a way to try to gain funds into the Maryland banking system, the geniuses in the Maryland banking system come up with, well, why don't we find a way to get the money from the federal banking system? So the Maryland legislature passes a law, a local law that says they can tax the Bank of the United States. So what that really means is they're going to go in and they're going to see McCulloch and they say, you have to give us tax money because you're operating within our state. And we deserve some money because you are a federal entity operating within our state. Well, we know today that doesn't make a lot of sense. But in 1819, it was an attempt. It was an attempt to get some money into the state banking system, and it was also a power try. Is the federal government supreme or is the state government supreme? So let's take a look at the notes there. So, as a result of the panic of 1819, the Bank of Maryland was short on funds. In an attempt to help fund that bank, Maryland adopted a tax on the branch of the second bank of the United States located in Maryland. McCulloch was the principal official of that bank. You can consider him the local bank president for the second bank of the United States. And of course McCulloch says, I'm not going to pay this money. And the question is, can a state tax an institution of the federal government? Because if it can do that, then a state can do things to all other entities, if you like, of the federal government operating within the state. So take a look at the other side. So John Marshall, the Marshall of Marbury versus Madison, is still Chief Justice, so it's a long-term appointment. And he says, the power to tax is the power to destroy. That's his actual Marshall quote in 1819. And he goes on to say, the power of the federal government is supreme over the state governments. And we know that today, but this is where it comes from. This is where the precedent begins. It's affirmed that the supremacy of the United States government is, that it affirms the supremacy of the United States government over the subordinate state governments under the federalist system. Meaning that part of federalism is a strong central government and subordinate state governments, and that's what's going to be affirmed in McCulloch versus Maryland. So the tax is overruled. What's the precedent? The federal government is supreme. And being supreme, all entities of the federal government in the future will be supreme over the various state governments. Next up is Gibbons versus Ogden in 1824. So this is the case of Gibbons versus Ogden in 1824. And in some cases, in some ways, it echoes the decision of McCulloch versus Maryland. So we're going to end up in the same kind of situation where the federal government is supreme. But some background. Both Gibbons and Ogden had been in a partnership conducting commerce on New York State waterways. Some lakes within the state, Lake George, the Hudson River, and things like that. And along the way, Ogden had received a license from New York State to be the sole provider, if you want, of this transportation service on New York State waterways. It seemed like a good idea for a while. And later on, Gibbons wanted to do the same thing. His partnership with Ogden had severed. And he turned around and he wanted to also operate on New York State waterways. Well, he had been told he couldn't. New York State turned around and Ogden had brought suit. New York State turned around and said, no, Ogden has the license, you do not. Ogden has sole control over commerce on New York waterways. Doesn't sound right today. It didn't sound right back then. So nevertheless, Gibbons is going to bring suit. It's going to work its way through the court system to the Supreme Court, hence Gibbons versus Ogden. Gibbons is the plaintiff, Ogden is the defendant, which means in the lower courts, by the way, Ogden had won. Because if Gibbons had won, it would be reversed. So the right of Ogden to have exclusive control over shipping on New York waterways has been affirmed by the lower courts, and we end up in the Supreme Court. And it's still John Marshall. And John Marshall is still going to rule the way John Marshall rules, but let's see how he gets there. So, a dispute arose over the ability to conduct trade on New York waterways. Ogden had been granted an exclusive license by the state of New York. Gibbons, who had been his partner, had obtained federal permission to engage in trade on the same waterways. Ogden sued in the lower court and won on the idea that his license was issued first and that the states can regulate commerce within their borders. Gibbons appealed to the Supreme Court. And part of the basis of the appeals is some of New York waterways are not solely in New York. The Hudson River is a good example. It separates New York and New Jersey. And to conduct trade on the Hudson River, as certainly a pertinent example here, would mean you're going between the states. And what would happen with New York's license when you're talking about trading between states? So John Marshall, still the strong Federalist, is going to rule exactly the way we think he's going to rule. Take a look. Yes, John Marshall is still around. This is a revisit of the McCulloch case in a lot of ways. And the question remains, which authority is supreme, federal or state? So Marshall ruled that New York State waterways could be used to conduct commerce with other states. The whole idea of, well, New York separates New York and New Jersey so you can trade back and forth. The Constitution grants powers to the federal government to regulate interstate trade, meaning trade between the states. So the decision is for Gibbons, citing the supremacy of the federal government in regulating interstate trade. So New York couldn't control trade like that with New Jersey, and Ogden couldn't have an exclusive license. So that's where we get back to the supremacy of the federal government. So what's the precedent? The federal government regulated interstate trade. Previous decisions can be used as precedent for current cases. So Gibbons used McCulloch as a precedent in turning around and saying the supremacy of the federal government. So what do we have here? We have a federal license is supreme over a state license. John Marshall, the strong Federalist, still agrees with that idea. And we're going to have a restatement of the precedent from McCulloch versus Maryland, which is the federal government is supreme. Next up, the very famous case of Dred Scott versus Sanford, the one that all of us know so much about, but there's a bit of a twist in it. So take a look. So here we are. The year is 1857. 3 years before South Carolina secedes, 3.5 years before the first gunshots at Fort Sumter. The nation is being torn apart over the question of slavery, and here is Dred Scott. Who is Dred Scott? Dred Scott is a slave. He's a slave that belonged to John Emerson. And for a good deal of Dred Scott's life, he had lived in the free territory north of Missouri and west of Missouri called Illinois. Well, he believed that he should be free because he was a slave living in free territory. John Emerson dies. John Emerson dies and he leaves all of his property, including Dred Scott, to his wife. So take a look. To Irene Sanford is his wife's name. So that's the idea of Sanford. But Dred Scott v. Sanford is not Irene Sanford. Because Dred Scott starts to figure out, well, how does this work? Can I turn around and get my freedom? And a local lawyer decides to sue for Dred Scott, and the local courts, Dred Scott loses. Irene Sanford is his owner and will stay his owner. Well, that lawyer is pretty smart, because that lawyer says, wait a minute, does Dred Scott really belong to Irene Sanford? And does some research and finds that no, he doesn't belong to Irene Sanford. He belongs to John Sanford. John Sanford is Irene Sanford's brother and lives in New York. And the way the laws worked, women could not own property. So the property that had been Emerson's should be John Sanford's, not Irene Sanford. Now, I had always wondered about this when I was in school, when I went to college, I did the research, and teaching all these years, I thought out the same question. How does a black man take a white man to the Supreme Court in 1857? I mean, let's face it. Let's face it. We were hardly a non-racist country in the 1850s. Don't you think that someone would have stopped Dred Scott from taking a white guy to court? Either by killing him or by silencing or keeping him out of the court system whatsoever? It doesn't make any sense. So people go around and say, oh, Dred Scott, you know, he lost because he was a slave. I always wondered, how did he get to the courts anyway? Because he was a slave. It doesn't make any sense. Enter John Sanford. John Sanford, brother of Irene Sanford, was from New York. He was anti-slave and he was an abolitionist. So when the lower courts ruled that Dred Scott actually belonged to John Sanford, not Irene Sanford, John Sanford had an interesting choice. He could free Dred Scott and his family, which he was certainly inclined to do as an abolitionist, or he could test the Missouri Compromise. He could test the law that said any state north of Missouri was free and thereby could not be a slave-holding state, and any slave that traveled into those states would thereby be free. And the Supreme Court held with that logic, every slave that ever traveled into free territory anywhere in the United States, under the justification of precedent, would thereby be free. So John Sanford was an abolitionist trying to get the Supreme Court to make a nation-changing decision freeing all slaves that had ever traveled into free territory. So John Sanford helped Dred Scott, even though it was Dred Scott v. John Sanford, and John Sanford was the defendant and Dred Scott was the plaintiff. John Sanford was simply trying to make a political point, because Dred Scott was going to end up free anyway. So let's take a look at this. There are many complicated details here. Scott originally belonged to John Emerson of Missouri, as I said. Emerson had taken Scott to the free territory of Illinois for a number of years. Upon his death, Scott was transferred to Irene Sanford, his wife. It makes sense in most situations. Wife inherits the husband's property, but not in this one. A federal court later ruled that Scott should have been transferred to John Sanford, her brother, because women could not own property. Well, John Sanford is not like his sister Irene. Scott claimed that living in free territory made him a free man. And John Sanford agreed. John Sanford agreed and wanted to set a national precedent rather than just freeing Scott himself. So off we go into the federal court system. And now, the Chief Justice in 1856 and 1857 was a guy named Roger Taney. Roger Taney was kind of a stooge. He'd been put in place by Andrew Jackson as part of a deal to defund the banks all the way back in 1835 and 1836. See the case. Seeking to avoid a national conflict during this decade of crisis as is known, ending the Civil War, Taney took a cue from John Marshall and issued a procedural decision. He didn't rule whether Dred Scott should be free or not. He said that Dred Scott had a valid argument. He went on to say the Constitution protects the people of the United States. He went on to say the Constitution states that slaves are 3/5 of a person. Thereby, they are not people and cannot bring suit. So yeah, the Constitution protects people, but Dred Scott wasn't a person. The case is dismissed. So the case is dismissed without an actual ruling on Dred Scott. What was really ruled on was Dred Scott's status. Now, some additional background information. The case was decided in the fall of 1856. James Buchanan was going to be the next president of the United States. And he turned around and he asked Roger Taney not to announce this decision until after his inauguration in the spring of 1857. That is very illegal. It is tampering with the Supreme Court system. And that kind of shows the kind of person Roger Taney was. Now, from the other perspective, the Supreme Court often makes decisions in light of the times. And we have to wonder what would have happened in the United States if Taney had turned around and freed Dred Scott, because two things would have occurred there. First of all, he would have said that all slaves in free territory, anytime their lives were thereby free. A lot of slaves getting freed all at once would have been a very bold move. And the second thing he would have said is that slaves can bring suit. And if slaves can bring suit, they can't be 3/5 of a person. They'd have to be an entire person. So he would intend, and then, in a sense, nullify the 3/5 compromise. And in nullifying the 3/5 compromise, he'd be nullifying one of the basic tenets in the United States Constitution. This was a no-win situation for Taney, and he took the easy way out. Okay, next up is a case that's loosely related to this. It has to do with Plessey and Ferguson. So we continue with our precedent-setting cases. We're going to deal with a case called Plessey versus Ferguson. Plessey's first name was Homer, and Homer Plessey was a mulatto. It was a term very common in the days to indicate a person of black-white ancestry. And Homer Plessey was 7/8 white, 1/8 black. Now if you figure that out, you have to go back 3 or 4 generations here to figure out that there was a black descendant in Plessey's history. Now chances are it was a slave woman who had had sex with her master, so we'll call that a rape. So way back, Homer Plessey was essentially, he came to being as a result of a rape. But that's not the point of this case, because now we're in 1896. And in 1896, there were a lot of mulattoes walking around the southern part of the United States from the old days of the slave masters doing what they wanted with their slave women. So, hence we have Homer Plessey. Now Homer Plessey looks white, which means someone had to squeal, and someone did. 7/8 white, 1/8 black, he looked white. Let's take a look at the situation in the case here. We're looking in the middle. Plessey v. Ferguson, 1896. Again, Ferguson was official of the railroad in the state of Louisiana. Homer Plessey was the plaintiff, Ferguson was the defendant. Homer Plessey was known as a mulatto. He was 7/8 white. In 1892, Plessey sat in a whites-only train car in Louisiana. Separate train cars are allocated for whites and blacks. Plessey argued that the separate cars violated the 13th Amendment and the 14th Amendment. 13th Amendment, certainly freeing slaves, and 14th Amendment is the Equal Protection Amendment, saying that everyone in the United States is afforded equal protection under the United States Constitution. So, here we go. And now, people always ask, how was Homer Plessey detected if he was 7/8 white? Well, somebody dropped a dime on Homer Plessey. This was a small town, and people knew who he was. And there were people who simply resented mulattoes. It was an ugly time in American history. The South was fighting with its history and its future at the same time, and Homer Plessey certainly was both, its history and its future. So, nevertheless, Homer Plessey is arrested for sitting in a whites-only train car. And once again, Plessey is going to be the plaintiff, Ferguson is going to be the defendant. It's going to work its way through the court system starting back in 1892. And in 1896, we end up with Chief Justice Melville Fuller. And it probably would have been, as in the Dred Scott case, the right thing to do to turn around and say, no, this is ridiculous. Separate train cars are kind of ridiculous. But he went a different way. And I've often argued in class that this was probably the safe decision for the day, because even though full integration would have been preferable, there were still a lot of wounds in the Old South, and I don't know how well it would have gone over. Certainly I'm an advocate for it, but it was a tough decision to make. So Melville Fuller turned around and said the 13th and 14th Amendments do not guarantee mixing of the races, whether it be in terms of how Homer Plessey came to be, or whether they have to be in the same public place, that wasn't their purpose. He goes on to say that the 13th and 14th Amendments only require equal treatment of the races. They have to treat them equally, but you don't have to mix them. Then he goes on to say, as long as equal accommodations are present for both races, then separation is indeed legal. Hence, separate but equal. As long as the white train cars and the black train cars were equal, then they could be kept separate. Blacks and whites could be kept separate. So here we have separate but equal is established, and Plessey had to pay a $25 fine, which was, a lot of money in those days. It's not like $25, probably a couple $100. So the precedent, separate but equal, is established. So that's going to set up the precedent for separate facilities for blacks and whites, not just in train cars, but hotels, shopping areas, restaurants, schools. As we go forward, it's going to be, the key case is going to be challenged at the beginning of the Civil Rights Movement. And that case will certainly be Brown versus Board of Education. But before we get there, we're going to stick one in between. The next case we're going to deal with, Schenck versus United States, is a clear case of civil liberties and what are our rights. What rights do we have in times of national emergency? The year was 1917, World War I was going on. The Russians had just withdrawn from World War I as a result of the Russian Revolution and Lenin's promise, I should say. Of course, it'll be a problem as time goes on. Nevertheless, Lenin's promise to withdraw from the war, and the United States was entering World War I. The Socialist Party in the United States has a significant following, and Schenck was a socialist, which is part of the background to the case. So in 1917, when a draft begins in the United States, when the draft is occurring in the United States, more correctly stated, Schenck starts distributing anti-war leaflets, encouraging people not to participate in the war that he considered to be illegal. So he's handing out these leaflets, and he's arrested for handing out these leaflets, because the United States government had just passed something called the Alien Espionage Acts, which sound a lot like the Alien Sedition Acts from John Adams, and they have a lot of the same intent. The Alien Espionage Acts were put in place to stop dissenters from speaking out against the United States government and our war effort in World War I. The Alien Act against immigrants, and the Espionage Act against American citizens who might have been committing acts against the United States government as a way of interfering with our war effort. So Schenck is handing out these leaflets, and he's going to be arrested. He's going to claim that the First Amendment guarantees him freedom of speech. So we're going to meander our way through the court system again. World War I is popular. It's a popular war in the United States. We're singing Over There, and we think we're going to make the world safe for democracy and freedom of seas, and Woodrow Wilson's riding high, and all that's going on. And in the middle of this, Schenck is saying, no, 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 don't go fight this war. So we end up in the Supreme Court in 1919. So let's take a look at the events. Schenck versus the United States in 1919. The U.S. entered World War I when the Russians withdrew in 1917, following the fall revolution. There were strong anti-socialist feelings in the United States, partly because the Russians withdrew and they left us holding the bag. Schenck was a declared socialist and was also part of an anti-war movement in the United States. It all sounds okay, because what he's going to do is speak out against the war. The U.S. has passed 2 laws to silence anti-war protests: the Alien and Espionage Act. And as I said, it should sound familiar. When Schenck distributed anti-war propaganda, he was arrested for violating those acts. So the question again, was he damaging the United States government, or was he exercising freedom of speech? If you looked at it in today's light, I think most people would say it was freedom of speech. But we can't look at the decision in light of today's politics. You have to take a look at it in light of the day that it actually occurred, because that's how the Supreme Court does these things. It rules in light of the local time period, not some other time period. So here we go. Let's take a look. So the Supreme Court, under Chief Justice Oliver Wendell Holmes, turns around and he affirms the lower court ruling against Schenck. So now the Supreme Court has upheld the ruling against Schenck. It came to be known as a clear and present danger ruling. Free speech is not absolute, said Holmes, and the government can limit speech that is harmful to national security. So in times of national crisis, then freedom of speech can be curtailed. Recent examples are, for example, the Patriot Act, and during World War II, certainly Korematsu. So, President, in times of national emergency, the government can take steps to put safety above freedom. Free speech can be curtailed for national security reasons. Think of Korematsu, as I said, and of the Patriot Act as more modern examples, if you like. So that will become the precedent for all future. To this day, it still holds that in times of national emergency, the government has extraordinary powers, and our freedoms are never absolute, and certainly not absolute during times of national emergency. So next we're going to shift gears, and we're going to deal with Brown. Brown versus the Board of Education, 1954. So here we are. The year is 1954. The case is known as Brown versus the Board of Education. Arguably one of the most famous cases in American history. And arguably one that pulls at our heartstrings, because it deals with a little girl named Linda Brown. Linda Brown had been denied her right to go to an all-white school that was very close to her house. Instead, she was going to have to go to a school that was quite a distance from her house, an all-black school. Under the Plessey doctrine, Plessey versus Ferguson, separate but equal was the law of the land. So as long as they were black schools and white schools, and they were thought to be equal, and certainly they were not equal, but if they were thought to be equal, then she would have to go to the all-black school, even if the white school was right across the street. Now, Brown is part of an omnibus case. There are actually several cases in the United States dealing with similar things. The whole idea of what will these local school boards do to provide equal facilities if they're separate? Will they provide busing to both the black and the white schools? It sounds like they should. These cases are all put together under the NAACP, the National Association for the Advancement of Colored People. And the lead attorney will be none other than Thurgood Marshall. Thurgood Marshall will be the prominent name that comes out of Brown versus the Board of Education. And he will be the first black Chief Justice, first black justice, not Chief Justice, first black justice on the Supreme Court, and he will be nominated by Lyndon Johnson in the 1960s. So let's take a look at this case, and let's see if we can see how this all came to be. Following Plessey in 1896, several attempts were made to overturn the ruling. There were many cases. They had to do with trains, they had to do with public accommodations, and each time the Supreme Court had affirmed Plessey. So it was a hard precedent. If you remember earlier in the whole discussion, it said the Supreme Court often rules on precedent. It's a hard precedent to overturn. So there was an omnibus case, because there were several similar cases. The NAACP decided to combine the action using the sympathetic circumstance of little Linda Brown, denied access to an all-white school near her house, and being forced to walk a great distance to the colored school. The NAACP sought to overturn separate but equal on the grounds that separate cannot be equal. So how do you do that? How do you prove that separate is not equal? Because even if they're not equal, they can be made equal. Meaning, if the black schools were lacking in a facility, had poor teachers, had poor supplies, a state could simply comply, even temporarily, by improving the black school, and now we fall into line with separate but equal. No. The NAACP had to prove that even if the facilities were inherently equal, which by the way was the case with Brown's school, the school she was supposed to attend was actually a fairly good school, relatively speaking, that even if you went to a separate school and were treated equally, you did not come out feeling equal. Let's see what happens. Do black children really feel equal to white children after going through these schools? And an experiment was conducted throughout southern states in which black children were sent to daycare centers. And in these daycare centers, there were dolls, black dolls and white dolls, both within easy reach, because one would say, well, they could reach one over the other. And observations occurred. Observations occurred and showed that the black children, time and time again, chose the white dolls. Regardless of where the doll was, they chose the white doll over the black doll. And with the parents' permission, these children were interviewed. And when they were interviewed, they were asked, amongst other questions, why did you choose the white doll over the black doll? And the reply, in almost every case, to paraphrase, is that the white doll is better. Now, where would children get an idea that white is better than black? Even if they're going to schools in which they're being taught that they're equal. The message is not coming out. The message is not working. They're leaving these schools feeling inferior to white children. So that was presented before the Supreme Court, but that's not enough. Even though it's a compelling argument that they're not being taught that they're equal, it's a compelling argument, it's not enough. There had to be more. So let's take a look. Chief Justice Earl Warren, he is the Chief Justice of the Supreme Court at the time. This case faced extensive litigation, including the change of the Chief Justice midstream. A guy named Fred M. Vinson died in 1953 while the case was being argued. And President Eisenhower appointed Earl Warren the Chief Justice. He told Warren, he said, I don't care what the decision is. That's the decision of the court, but I want a unanimous decision, because anything less than unanimous is going to tear this country apart. A 5-4 decision, one way or the other, really does not answer the question of separate but equal and whether integration should occur in the United States. So those were Warren's marching orders. The NAACP and Thurgood Marshall used the doll demonstration that I just explained to establish that black children were being raised to feel inadequate when compared to white children. Well, Earl Warren got his decision. Precedent, separate can never be equal. Plessey is overturned, and the modern civil rights movement now gains traction. It was hard overturning Plessey, but that doll experiment was very compelling because it didn't seem to matter. It didn't seem to matter what you did to the facilities. If you didn't mix the children, they were being raised differently with a different set of values and norms, thereby separate can never be equal. Now, as a coda to this, remember the Supreme Court turns around and decides whether the law is constitutional. So they said separate but equal is unconstitutional. And you know what the southern states said? So? Because in order to change it, you would have to have legislation integrating the schools, and the Supreme Court doesn't legislate. And the southern states certainly were not going to pass this legislation to integrate their own schools, so you would need federal legislation to integrate those schools. Well, the South holds a significant amount of sway in the House of Representatives and in the Senate. So you were not going to get federal legislation to integrate those schools. So even though Warren had said that separate but equal was unconstitutional, the southern states did nothing. So now we have an interesting turn. In 1955, the same Supreme Court reconvenes because nothing's happening. And at this point, they do something called judicial activism. They turn around and they order the southern states to integrate with all possible haste. They order them to integrate. It's called a judicial action. They take a judicial action, hence judicial activism, and they order the southern states to integrate. Very questionable whether that's constitutional or not, but who's going to judge? Because the Supreme Court decides constitutionality. Well, that's going to lead to a lot of things as we go forward, including the 1957 situation at Central High School in Little Rock, Arkansas, where you have Governor Falva staring down President Eisenhower as to what's going to happen if they refuse to integrate. The next case is going to be Miranda versus Arizona, and it's the famous case of the rights of the accused. So here we have Ernesto Miranda. It's 1963 and we're in Arizona. And Ernesto Miranda is arrested for kidnapping and rape. It's not even a question of whether he did or committed this crime or not. It's a question of how is he going to be handled. Now, in 1963, the civil rights movement is heating up, certainly We have the March on Washington, the I Have a Dream speech going to occur in 1963. We have the Kennedy assassination occurring in 1963. Things are tense in the United States, for sure. And Ernesto Miranda is arrested in Arizona. Now, just think about his name. He's Hispanic. Arizona, southern part of the United States, a lot of issues with immigration. Chances are, I wasn't there, I'm reading into it. Chances are there was a little bit of racism on the police department side. I can almost imagine the guy with the big hat and the sunglasses saying, "Okay, boy, what do you have to say about this?" Well, Ernesto was arrested, and he was charged, he was questioned. And then after 2 hours of questioning, he was asked to sign a confession, which was written in English. Funny thing about it, Ernesto couldn't speak English. So not only was he questioned without an attorney, he signed a confession that he couldn't read with the promise that he was going to go home. Obviously, the rape and kidnapping is certainly terrible, but that aside for a second, that is not the way we want to handle accused people in the United States if we want their sentences to be upheld. So let's take a look here. March 1963, Ernesto Miranda was arrested for kidnapping and raping an 18-year-old woman. After a 2-hour interrogation, he signed a confession. Well, he was never informed of his right to counsel. The confession was written in English, and Ernesto did not speak English. Now, in defense of the police, the idea of telling him he had a right to counsel had not yet occurred. It was assumed that people knew that they had these rights, and the police were not routinely informing them of these rights. So the police didn't act incorrectly by not telling him his rights. They acted incorrectly in denying any situation like that to him and making him sign a confession in English that if a lawyer had been there, it certainly would have said, "Ernesto, this doesn't work, you can't even read this." So anyway, go a little further. After his conviction, Miranda's court-appointed attorney appealed to the Arizona Supreme Court. The court upheld the conviction, and the appeal was then granted to the Supreme Court of the United States. So again, Miranda versus Arizona. Miranda is the plaintiff, Arizona is the defendant. And we're going to go to the Supreme Court and Chief Justice Earl Warren again. The Earl Warren of Brown versus Board of Education thing. And that Supreme Court in 1966 took 3 years. Now in those 3 years, the civil rights movement had taken on greater awareness in the United States. John Kennedy had been assassinated. Malcolm X had been assassinated in 1965. So it was a very tense time. And this was a very bold move by Earl Warren. Earl Warren's Supreme Court ruled that Miranda did not have to ask for counsel. He should have been made aware of his right to counsel. In other words, it wasn't up to him to know, he should have been told. They went further on to say his confession was inadmissible for 2 reasons. The whole right to counsel was not presented to him, and he couldn't read the thing. It was written in the wrong language. So his conviction was nullified. Now so many people say Ernesto walked, that Miranda walked based on this. Do you really think that a person who committed rape and murder is going to walk based on something like this? No. Arizona went back to trial the very next year. They went back to trial the very next year, and Miranda was convicted in 1967 based on being picked out of a lineup and out of statements from his sister, Ernesto's sister, where he bragged a little bit about being involved in this whole thing. So he was sentenced to 15 years, but he was paroled in 1972. For a while, between 1972 and 1976, there's a story that Ernesto made money as kind of a pseudo-celebrity. He would sign those little Miranda cards the police were carrying. He'd put his signature on like an autograph. Ernesto Miranda on the Miranda rights cards, because after this, police across the United States started carrying these little cards so they could read Miranda rights. You have a right to remain silent. You have a right to an attorney. If you've ever seen a police show or been arrested, you know how that card works. And then he died in a barroom brawl in 1976. He was stabbed to death in a barroom in 1976. And supposedly, urban legend here, that the police who arrested the person that stabbed him were taking a certain amount of pleasure in reading that person his Miranda rights. Because Miranda had created a tough situation. But it also cemented the idea of the rights of the accused, because if you do not uphold the rights of the accused, chances are that conviction is going to be thrown out. And what if the accused is innocent? Innocent until proven guilty. Miranda could very well have been innocent, and he would have gone to jail. There are many cases over the years where innocent people have gone to jail, and they found either procedural problems or they, through modern DNA evidence, found the person was convicted of a crime he or she did not commit. So the precedent: no defendant can be questioned or tried without being informed of his rights and voluntarily waiving them. They have to tell you your rights, and then you have to turn around and say, I waive my rights. It's not enough to say, do you understand them? You have to turn around and say, I waive them. The policy of reading the Miranda rights became a common policy. So now it occurs across the United States. So here we have it. We have a collection of pivotal Supreme Court cases, each one setting a precedent. It concludes this presentation of Busch history, and I'll look at pivotal Supreme Court cases 1. There will be an additional one. Keep watch for that, and that'll deal with cases going up to the present day. In chronology, in terms of American history and my coursework, I am in the time of the Agrarian Republic, because that's when Marbury versus Madison is visited while Jefferson is president, and that's why I present this at that time period. It coincides roughly with Chapter 9, the variables out of many, but obviously goes much further into the future. So, that's it for now from Busch History, and check the website, www.buschhistory.net/YouTube. But if you just go to the buschhistory.net, you will see all the information about these videos. And have a good day. Bye.